It meant a lot that the Supreme Court ruled in my favor, and it was, I feel like it wasn't only a win for me, but it also was for 50 million other students. Because I was frustrated at the time. I was 14 years old, and I expressed my frustration the exact same way teenagers do today. And I feel as if young people need to have the ability to express themselves without worrying or being scared of being punished by the school.
Yeah, she had a real nasty mouth back then, but she's a winner this morning. A cursing cheerleader and hot pursuit police chases. They're the topics the Supreme Court ruled on yesterday. Our Justice Correspondent Candace Kelley is here with the stories in this week's edition of Open and Shut. Good morning, Candace.
You gotta wait for the little graphic.
Open and shut,
we got
Candace.
a budget now.
Yeah. Candace, we've been talking about this cheerleader and her really nasty potty mouth, right? And what she did all those years ago. The vulgar message on her school, about her school rather, on Snapchat after she didn't make the varsity squad. She was off campus at the time, and you made that point. Were you surprised by what took place here?
You know, I wasn't surprised at all, because here the Supreme Court justices were saying that when you're off campus doing things that are not related to school, because sometimes students are off campus doing things that are related to school, but when they're not related, we don't have any jurisdiction over that. I mean, it's hard enough that the schools are trying to control what's going on within their four walls during the 5 days of the week. I can't imagine that they wanted to get into this whole idea of anything that you might say at some barbecue or picnic on a Saturday morning in another state would have anything to do with what's going on in the classroom. It's something that is out of bounds in terms of what the school can do, and it's something that the school probably would not be able to control if you think about what they would have to do in order to carry that whole idea out of controlling everything that a student says wherever they are. So I wasn't surprised. It would have been a big task to take on.
Yeah, so Candace, SCOTUS says the school can't punish her, but they did say that there were times when the school could jump in and punish students who post while off school grounds. When is that possible?
Well, it's possible when what the student does or says or posts actually becomes disruptive in the classroom. So we're talking about situations of harassment or bullying. Those are the things that the school can still jump in on and say, listen, we've got jurisdiction over that. And actually what you're doing is being disruptive in the classroom. If you're harassing or bullying a student, for example, that's going to create tension on campus. This really goes back to the 1969 case of Tinker v. Des Moines, where this school was said to have the right to not have the right of to oversee what a student says in class. That case was established in 1969 to say that students have a First Amendment right in the classroom as long as it is not disruptive. So they're really harking back on what they've been saying for decades now, that if it's disruptive, then you're out of bounds there, and that's unacceptable.
So this, Candace, was a 8-1 decision. I really want to know who the one justice was. Maybe you'll tell us. But they have been very united, surprisingly so, given the makeup of this court. What's the takeaway there? Because the other cases, involve hot pursuits. The high court ruled police don't always have an automatic right to follow a suspect into a home without a warrant. So talk to us about how united they've been and the rest of these issues.
Yes, when we look at the case having to do with adoption, when we look at Obamacare, when we look at the NCAA and that decision and the rights that they gave to college students, we're looking at a court that is not as divided as you would think. By the way, that was Justice Clarence Thomas who dissented on this particular case. He said that the schools actually did have jurisdiction and have been controlling what students have been saying over the decades. So he's our outlier there. But in terms of this whole idea that the courts are presenting this unbiased presentation of who they are, I think they're sending a message to the people that they are in charge here, and that what's going on the outside politically is not going to influence what they say inside of the court. It also really kind of forces you to look at these justices individually. Justice Kavanaugh has had some real surprises here in terms of going in terms of the majority with the liberals, he's been one of the people who has crossed over. And Justice Amy Coney Barrett, too, surprisingly, has crossed over in about 78% of the cases with the majority. But what still is outstanding there are some hot button issues that we still haven't heard about, and that is Voting Rights Act. And I am sure that we will see a little more of the true colors and nature of who they are when we get to those cases. So the verdict is still out there.
I'm still a little bit shocked when you're talking about Clarence Thomas being the dissenter when it comes to vulgar speech. That's kind of ironic, to be honest with you. Just kind of.
Is a little irony there, Mike? Is that what you're saying?
Hey, a little ironic. The other cases, as Sharon said, involve hot pursuits. The high court ruled police don't always have an automatic right to follow a suspect into a home without a warrant, but that's with a misdemeanor. Am I right there, Candace?
Yeah, so this is a situation where we're talking about, specifically, there was a plaintiff here who was being pursued by the police. He didn't really know he was being pursued, and in that case, he went into his garage, and then the police officer kind of slipped under the garage door, and then he arrested him for a DUI. And he said, wait a minute, I'm on my private property. What are you doing? You need a warrant to actually come in here. You shouldn't be in here. So this whole question of hot pursuit, what do police officers do when they're in the middle, right, in the process of following someone who is fleeing? The courts ultimately said, or the Supreme Court ultimately said, even if a suspect is fleeing, if it's a misdemeanor, they still have a right to privacy in their home. You can't just go in and barge in their home if it's a misdemeanor. Another case that they decided had to do with somebody having loud music. If somebody has loud music, you can't bust into their home. If they decide to go in, you still need a warrant. If you have time to get a warrant, then you should do so, especially if it's a misdemeanor. And that's what we're talking about. No one seems to be in threat of dying. There seems to be nothing in jeopardy. If we're talking about a low-level misdemeanor, they're at home. That is their private space. Officers, you must preserve it.
So, Candace, you know, this seems like it could be murky, or at least a little bit. Why did the court decide the way that it did?
Well, I think ultimately the bottom line is that if you set a precedent with this in terms of police officers entering into your home because your music is loud, what is that going to say maybe when they're not in hot pursuit? What type of precedent does this set when you've gone home? They want to preserve this idea that your home is your sanctuary, and if you want to get in there, you need a warrant. Let me know on paper from a judge, what do I need to get in this home for? It certainly can't be because he's playing Ice Cube too loudly, right? That's no reason to bust up into somebody's home. So in that regard, they want to make sure that this whole idea of a warrant remains intact, and that you and Mike, we all have the right to just be in our home and to be left alone from police officers just barging in for no reason at all. But you know, Sharon, you did say it gets a little murky, right? And it does, because how do you know whether or not something bad is happening on the other side? Why is this person fleeing? The officer does have to make a decision as to whether or not they can go onto somebody's private property if they don't know all the information. So split decision making in the future in terms of this particular case.
Yeah, that's big. Sense. And if you get a warrant, I'm gonna need you to knock.
Yes, yes. And there's a difference, too, though, when you are dealing with someone who you know has left a crime where a felony might potentially involve, right? So if you have heard that somebody's been shot and there's in the middle of a burglary and they're saying, go get this suspect, well, then you have a more inclination to believe that, you know, something worse is going to happen. This is a felony, and in that case, go ahead right in. You don't need to get a warrant. But simple music being up loud, or someone who doesn't even know that they're being chased, you can't go in at that time.
All right. Candace Kelley, once again, like Sharon said, this is why you're the expert. This is why we love you. Thank you for starting your day with us. This has been another edition of Open and Shut, and these cases have been closed for this week.